Buenos días a todos y a todas. Bienvenidos al Congreso Garantía de los Derechos de la Ciudadanía frente a la inteligencia artificial empleada por las administraciones públicas. Thank you. Seguimos con el Congreso y en el día de hoy vamos a empezar el panel 5 referido a casos de uso y riesgos específicos de uso de inteligencia artificial por las administraciones públicas. La mesa va a ser en inglés, por tanto, a partir de ahora vamos a usar esa lengua, si bien es cierto que las preguntas, que no os limite el tema del idioma, porque en realidad lo que interesa es que todos podamos seguir aprendiendo, no importa el idioma que utilicemos. Good. In the panel, there will be six speakers that will have 15 minutes in order to present their studies. The first one is Arianna Vedaschi. She is attending online. She is a full professor of comparative public law at Bocconi University in Milano, Italy, and she is a member of the Buffy Research Center of the same university. Her research focuses on legal responses to political and technical emergencies, as well as on their impact on human rights and personal freedoms, on which she published several books, articles in top journals, and chapters in volume. She is now presenting her study on artificial intelligence, counterterrorism, and rule of law. When she finished, we will show the cover of the book that is that contains this study. So, Arianna, thank you for presenting. It's your time.
Muchas gracias. Solo dos palabras en castellano y en español para agradecer a todas y todos vosotros por haber organizado y armado esta conferencia estupenda. Lamento mucho de no estar ahí en Valencia, que es mi universidad, y saludos a todas las amigas y los amigos. Ahora voy a hablar en inglés, pero por las preguntas, observaciones, el castellano está bien, puedo entender y me gusta practicarlo también si no lo hablo como nativo hablante. Entonces, muchas gracias. Well, in my presentation, I'll address the use of artificial intelligence and, in particular, the biometric recognition technologies for security purposes in the EU.
Can you please be closer to the microphone so we can hear you better?
Yeah.
Thank you so
much. I can also. Now?
See? Okay. No, it's good. Thank you. Thank you so much.
Okay. So in my presentation, I'll address the use of artificial intelligence and particularly of biometric recognition technologies for security purposes in the EU, in the European Union. In the first part of my presentation, I'll start from the perspective of EU law, of the European perspective. So I'll analyze the recent AI Act, Artificial Intelligence Act. And then in the second part of my presentation, I'll focus on domestic reaction, taking Italy as a case study. In my conclusions, I'll consider whether or not the emerging legislative framework is pushing towards higher or lower standards in terms of human rights protection compared to the pre-AI Act age. Before beginning, I'd like to point out that this presentation draws from a recent book, as Rosa mentioned. The title of this book is Artificial Intelligence, Counterterrorism, and the Rule of Law at the Heart of National Security, published by Elgard and co-authored by Chiara Graziani, a young colleague of mine. I will be more than happy to share the link of the book with all of you, because the book is in open access, so it's possible to read it. Let's start with the first part of my presentation, where I look into how biometric recognition technologies for addressing security threats are regulated at the EU level. Well, according to Article 5 of the AI Act, real-time biometric recognition in open spaces is prohibited. So here we can read a very direct, a very clear provision about this kind of advanced technologies. We have a ban, a prohibition. So law enforcement officers are prohibited from using real-time recognition tools in publicly accessible spaces, including public roads, squares, and so on. As I said, this Article 5 of Artificial Intelligence Act sets a very clear provision. The ban applies to law enforcement activities. Nevertheless, two important aspects should be highlighted. First, even within the law enforcement, so even within the prohibition area, the Artificial Act provides for some exceptional circumstances where biometric recognition is allowed, among them citing the prevention of specific, substantial, and imminent threat to life or physical safety, or again citing a genuine and present of genuine and foreseeable threat of terrorist attack. In this case, and I would like to stress counter-terrorism, so terrorist attacks, real-time biometric recognition can be used upon a prior authorization by a judicial authority or at least by an independent administrative authority. Therefore, what is banned, the real-time recognition system, is ultimately allowed in these specific circumstances and above all to counter terrorism, to prevent, to react terrorist attacks. A second aspect that I would like to underline is that the ban, the prohibition, as I said, applies only to law enforcement activities. Yet, the same technologies might be used in national security operation in activities classified as national security, which fall outside of the scope of Artificial Intelligence Act. And more generally, national security is beyond the EU law. According to Article 4 of the European Union Treaty, national security is not a European area, is a domestic domain. So it's not covered by the AI Act, is not covered by European law. On the top of that, counterterrorism lies at the boundary between national security and law enforcement, which normally refers to public security. Normally speaking, law enforcement is public security, but it's not national security. And national security, as I said, is a domestic domain. However, counterterrorism is a national security domain. For example, operations carried out in a conflict setting or carried out by intelligence services, by intelligence agencies. They are conceived as national and not as public security operations. This scenario leads us to an important consideration. I would like to say a general consideration. Well, by introducing this counter-terrorism exception to the general ban, to the general prohibition on real-time biometric recognition, EU law ends up indirectly regulating something that falls out of its scope, something that is beyond European Union action, since counterterrorism is national security, or at least lies in the borderline between public security and national security. This approach, as I said, from a general perspective, marks a trend which seems to go beyond the formal national security exception on the EU primary law. So the trend, the tendency taken by the European Union institutions to reach domains that, in theory, are outside of its scope, are beyond its domain. Given the main changes in the EU, let's focus on the second part of this presentation on the domestic reaction, taking Italy as a case study. I would like to say that two important elements. First element, Italy, like other member states, had already been experimenting biometric recognition technologies in law enforcement activities before the enactment of the AI, before the Artificial Intelligence Act. Specifically, in 2017, the Italian Minister of Interior started using SARI real-time, a system of real-time facial recognition deployed during major events to compare people's faces with the data contained in a database managed by the government, by Italian Ministry of Interior, and storing the images of criminals, irregular migrants, and even of those who had applied for a visa extension. Well, in 2021, the Italian Data Protection Authority found that this system, called SARI, did not respect several data protection guarantees, such as the need for a clear legal basis and clear and precise criteria to define in which situation it could be used. Following the opinion of the Italian Data Protection Authority, the Italian government, specifically Ministry of Interior, started using another version of SARI called SARI Enterprise, which is a non-real-time tool, meaning that the identification of face of people takes place after the collection of the facial image under a human being supervision, under the supervision of police officers. So we have a human oversight. Moreover, we need to remember that in April 2025, a decree law, then converted into a law, passed in April 2025, allowing police forces to wear body cams when recalled operational activities and their execution. Although these are not facial recognition tools, they could contribute to collecting images that are then compared against existing databases, so giving rise to a form of surveillance. Second aspect that I would like to highlight is that the AI Act is a EU regulation, so a directly applicable act, not requiring national implementation. Nevertheless, due to its complexity, member states, among which Italy, are adopting pieces of legislation to adapt, to align their legislation, their legislative frameworks, and ensure compliance with the new European rules, with the AI Act. Recently, in September 2025, the Italian Parliament passed a law number 132, which addresses several aspects of the AI Act and try to make the Italian system compliant with the AI Act, and more in general, to give Italy its own legal framework on artificial intelligence. When it comes to real-time biometric recognition in public spaces, however, there is no specific norm in the new Italian law, except for one delegating the government to issue a legislative decree, decreto legislativo in Italian, on the use of artificial intelligence in criminal investigations, which may include biometric systems in counter-terrorism. The point is how the Italian government will exercise delegated powers deriving from this new law, the law 132. Why will be the approach of the Italian government? On the one side, critical voices pointed out that leaving the regulation of such a matter to the government is risky. On the other side, however, the government will act throughout a legislative decree that in Italy, under Italian law, is an act that not only is enacted under parliamentary delegation, so we have a previous legislation, a previous statutory taken by the parliament, but also has the same rank as a statutory law, so is a primary source of law, and so the decree can be scrutinized by our constitutional court. In conclusion, the fact that an EU regulation of artificial intelligence now exists is undoubtedly a step forward, if compared to no regulation or to the need to adapt pre-existing regulation and sometimes old rules. At the same time, if one looks into the specific issue of security, this regulation is a sort of slippery slope. As a matter of fact, on the one hand, it seems to be strongly driven by human rights considerations, since it bans a controversial practice as a real-time biometric recognition. But on the other hand, if we look at the prohibition more closely, we find out that many loopholes remain, all of them stemming from the blurred line between public and national security, on which counterterrorism is a primary example. Let's now turn to the specific Italian situation, but something similar can be said regarding other member states that had already experimented biometric recognition before the AI Act, such as Germany or the Netherlands. For sure, the fact, again, that now a domestic legal basis exists is an important improvement compared to the previous lack of a legal basis. However, it is to be seen how specific legal framework, for example, in Italy, the forthcoming legislative decree, are going to be shaped, whether they will be sufficiently clear and precise, how the notion of terrorism prevention as an exceptional circumstance allowing these tools will be interpreted. It is quite important, the interpretation and the definition. In short, the current scenario is not totally negative, totally detrimental in terms of human rights. yet it certainly deserves close monitoring. Some think quite understandable, considering that we are at the very early stage in regulating such an advanced and continuously evolving technology. Thank you for your attention. Muchas gracias por vuestra atención. Estoy a disposición por pregunta. I'm open to questions and comments when we want. Thank you so much.
Arianna, thank you so much for your presentation. We are moving forward very quickly because we've run out of time at some point. So I'm going to introduce very briefly all the speakers so they have full time for their presentation. Next speaker is Guillermo Lazcoz Moratinos. He is a postdoctoral researcher at the Center for Rare Diseases and a member of Research Ethics Committee of Carlos III Health Institute. He is going to talk about implementing AI systems in public health care, safe words for patients and healthcare professionals. Let me just, it's here.
Okay. What I don't know is whether they can see the presentation online.
It's not.
Okay.
It's only
no worries. Thank you so much, Rosa. Thank you so much to the organization. Okay, like this is better. Okay. You only missed that I was saying thank you to everyone here in the organization. This presentation is part of a larger project that I'm currently working on. Due to the limited time that we have, I decided just to bring 2 use cases, and I will be focusing on one safe word on human oversight, and I think that many of the things that you will see here will remind you of some of the discussions that we already had in other topics yesterday morning. So first, no, this one is, I think it's not working, or maybe it's off. Okay, nice. So before presenting the 2 use cases, let me show you a bit the different legal frameworks depending on the depending on the different kinds of AI systems that we may implement. And here I will be focusing only on the scenarios that we may find regarding the application of medical device regulations and the AI Act. A brief note for those not familiarized with the medical device regulations. Is this kind of CE marking EU regulation for EU products commercialized in the European Union. So it's aimed at regulating, among others, software, including AI, with specific medical purposes. This means diagnosis, prevention, monitoring, prediction, prognosis, treatment, alleviation of diseases. They provide a risk-based classification, similar to the AI Act, but in another way, where Class 1 medical products just need a self-certification procedure to get the CE marking, whilst Class 2 and Class 3 devices require the assessments of notified bodies for this CE marking. What it is also important to know is the link between the medical device regulation and the AI Act. Very briefly, Class 2 and 3 medical devices, when they have also AI, they are not only AI medical devices, but also high-risk AI medical devices. Why is this? Because according to the sectoral regulation, they need to go through the notified body. So this is the link that the AI Act makes for the high-risk classification in the AI Act. So regarding the different scenarios that you can see here, we have first AI systems that have no medical purpose at all and are not of high risk, where MDR and the AI Act are not applicable, like the automatic transcription of patient records during doctor's appointments. It's not that these systems do not have any risks, but that those regulations are not applicable. Would be applicable, for example, the GDPR for this kind of AI system, okay? Then we have high-risk Annex 3 systems that have no medical purpose. For example, the systems intended to evaluate and classify emergency calls that we saw yesterday. Here is not applicable the medical device regulation, but it is applicable the AI Act as a high-risk system through to the Annex 3, okay? And then in yellow, you have scenarios where developers have not made the right decisions, okay? So misqualified AI systems that have a medical purpose, for example, systems that provide information for diagnosis purposes but are not certified as such, or misclassified AI systems that go not to class 2 or class 3 and therefore are self-certified software, meaning systems that provide information for diagnosis but are classified by the developer as other software. And then the last category is about high-risk AI systems in Annex 1, according to the AI Act, that have a medical purpose, so they are both a medical device with AI and a high-risk AI system, like systems that provide information for the diagnosis of melanoma. Okay, let me have the time here so I can control myself. So, the two use cases. The first of them is DX-GPT. It's LLM models intended to support diagnosis according to the provider website. And it works, you actually can test it online, okay? So it provides you provide a brief description of the patient and the symptoms of this patient, and the tool provides a list of possible diagnoses, what fits, what not, with the description that you have, and then you can fine-tune it. Initially was conceived for rare diseases, and on the regulatory status, the web page actually says that it is not a medical device because it is provided solely as a clinical decision support tool to assist qualified healthcare professionals, not be relied upon as substitute for medical judgment, diagnosis, or treatment. This is being recorded, right? Yeah? Where is implemented this system? This system is offered for free to the, at least in those two cases, is offered for free to the healthcare public systems. In Madrid, it is being implemented as a tool for general practitioners where for difficult cases that have no diagnosis at all. So in principle, it is aimed at the rare, for rare disease cases where it can provide some information that general practitioners wouldn't have in other scenarios. But in the second case, Salud GPT for the Servicio Aragonés, it is being implemented in June this year. It is open to all the clinicians, public clinicians, and it is aimed to be valid both for the rare diseases cases, but also for any kind of disease. Here, just to bear in mind, the only test carried out for the implementation of both is like service to the clinical practitioners. So no test, no study, no nothing, just service, okay? So this is the first use case, and this is the second use case, okay? This is Quantum Skin. Is developed by a spin-off, but it's actually property of the insurance company Assisa. The product is actually available for 75 euros to everyone. But in this case, I'm studying the implementation in Osakidetza, which that was awarded with a contract of 1.6 million some years ago. So on this, this is about, well, non-invasive, fast and easy test for the detection of malignant dermatological lesions. Okay. It basically gives a probability on the malignant lesion that you take the image from. On the CE marking here, it says that it is actually CE marked. I have several doubts whether it's class 2. I think it's class 1, but this is I'm not sure about it. I have my own intuitions, but I think it's only classified as class 1, and therefore would not go to the AI Act, okay? It's just self-certified. What says Osakidetza, the public Basque healthcare system, says about this system? Well, if you go to their public website, I actually found interesting that they have this analysis. It's not an analysis, but this analysis about discrimination, human oversight, and risks. On the human oversight part here, you can see that Osakidetza says that it is only an aid to prioritizing work lists. The final decision always rests with the dermatologist, okay? It explains also on no discrimination here, explain whether, if it's applicable, any measures to promote equality, non-discrimination, blah, blah, blah. Bias, not applicable at all. And known risk associated with the system and methods uses, there are no risks as the clinical use case is the prioritization of the current work list for physicians without excluding any patient from the work list, so that the physician can give greater and earlier attention to images cataloged by the AI system as having a high risk of being malignant. So, well, actually, it's quite surprising. I really recommend this research by Thibio, where they explain, yesterday we had the opportunity to discuss on false positive, false negatives, and so on. This research by Thibio explains really well how this system is or not precise, and how it can result into discrimination. So I really recommend this one. And actually what we encounter with these two case studies is what I call the Schrodinger's elephant in the room. So it's this challenging balance of the developers between selling an accurate and clinically useful AI product that it is going to revolutionize clinical practice, but at the same time, they have to explain that this product does basically nothing. It's nothing. It's merely an accessory support for clinical activity, so it's really great, but it does basically nothing. It's just like a new chair for the doctor. Okay, nice. And who is holding this balance? Here we have the fancy human in the loop. Because why? We see it in here, it's just a help to prioritize. We also see it, it's not a medical device, it's just a clinical decision support to assist and so on. So it's that fancy human in the loop there holding everything. And then this position brings me to the two souls of human oversight as a safeguard. Here, I don't have the time to go on with, but basically, it is not only from the developers' side, but also in the law. We have two souls of human oversight, two perspectives on human oversight. The first perspective is about human oversight protecting us, it's like a wall, protecting us from the harmful risk of AI. Whilst in the second place, we have human oversight as just one more element of the AI governance, and that will not work without the other elements. So this problem is actually brought to the law. If you take a look at, I don't have many time, but if you look at many legislations, you will find the two souls. Why I see this, for example, on Article 14.5 of the AI Act for remote biometric high-risk AI systems, you will find this human oversight protecting soul. Why? Because it's, actually I have it around. It says about these human oversight measures on remote biometric identification, those systems shall not take action or decision on the basis of the identification resulting from the system unless the identification has been separately verified and confirmed by at least 2 persons. Why 2? Who knows? But it's just throwing another human in the loop but we say that, okay, 1 is not enough, 2 is good to protect us. While if we take a look at the Article 14 plus 26, there we see human oversight more integrated in the full AI governance framework. So, just to conclude, since I'm running out of time, human oversight will not work as a safeguard for patients where first, legal obligations are not understood in relation to other safeguards, and also where organizational measures by developers do not follow this same logic, especially where legal obligations like the ones in the AI Act will not apply. And then, likewise, human oversight will become actually a risk for clinicians in these scenarios. We are talking about the pilot error phenomenon, where we are actually blaming and taking the responsibility from others to the individuals due to, for example, inadequate training, flawed procedures, poor designed human-machine interfaces, or other organizational pressures. So in this scenario, who will like to be that fancy human in the loop? Who will want to be that pilot of the AI system? This is all. Thank you so much.
Thank you, Guillermo, for adjusting so perfectly to the restrictions of time we are suffering today. Following up, the next speaker is Juli Solé. He's a law professor at the University of Barcelona, and he is the co-director of the Barcelona Chair on Housing Studies. He's a member of the European Group of Public Law and the European Network for Housing Research. He is today, he's talking about artificial intelligence, urban planning, and the right to housing in smart cities. Thank you so much. I have 15 minutes. Sorry, I cannot present you the way I would like to, but thank you.
Gràcies, Rosa. Bon dia a tothom. Un plaer estar aquí. Y voy a cambiar al idioma de la mesa de hoy. Good morning. It's a pleasure to share with you the table. And as Rosa said, I'm going to focus today in the use of artificial intelligence in the field of urban planning and housing. The structure of my presentation today will be the following. I will consider some ideas in the introduction, then I will go directly to the use of artificial intelligence in the field of urban planning and housing, and then I will consider a controversial question, which is the possibilities and limits of artificial intelligence in the field of administrative decisions in this area, in this specific area, and then I will finish with some conclusions and questions. Let's go with the first point. Yeah, I mean, I do think that artificial intelligence can be very useful to process big data and automatic city management and making it more efficient today in the field of urban planning and housing. But we have to consider some questions. I think that Guillermo's presentation was excellent, and mine will be complementary probably. Okay, so I will focus especially in this interaction between humans and machines. Okay, can we imagine, that's my question, can we imagine an artificial intelligence writing urban planning, ordinances, regulations, issuing building permits, imposing fines, sanctions in the field of the use of the land in the cities and the houses? So this is not science fiction, because we are going to see immediately that Madrid is preparing itself for this scenario. So let me, please, before going to Madrid, explain briefly the experience of Breeze in Vienna. They are trying to do exactly that. They are trying to use artificial intelligence for developing the administrative function of issuing building permits. Okay, I give you some links, and we don't have time. There are beautiful videos. But let me underline the case of Madrid. Madrid, some months ago, launched a preliminary market consultation in order to prepare a public procurement tender for an administrative contract with the idea of automating urban planning functions, in that case, granting building permits. This is the preliminary market consultation, consulta preliminar under our legislation, the Spanish legislation, and here you have the tender process, which is currently underway. So that's really interesting to see how Madrid is designing this externalization, this contracting out, in order to automate those functions. Even in the field of regulation, it's not impossible to think about the possibility of artificial intelligence designing rules in the field of urban planning. I don't know any example, but I do know this Brazilian example in relation to water meters, and it was a piece of information which was known all around the world. You have the Washington Post article here. So, is it possible? Under which circumstances? With limits or not? I'm going to consider both rulemaking and adjudication in the field of urban planning and housing. Very briefly, obviously. If you're interested in the topic, I can recommend you to take a look to this book that we have published, with the European Group of Public Law. This is not open, this is a pity, but there are other resources open access, so I suggest you to see them for more details. Let's go. The use of artificial intelligence in the field of urban issues, it's considered in several reports. I'm not going to insist about that. You have here one. And the basic idea is that artificial intelligence is being used more and more for cities, including the field of urban planning and housing, in relation to the idea of a smart city. I'm not going to talk here today about a smart city. I'm going to talk specifically about the use of artificial intelligence when developing administrative powers. What kind of uses in the field of urban planning? Well, I can identify at least several possible uses. For example, we know about the incredible capacity of data processing of those systems. So the possibility of analyzing big data when regulating the use of land is obvious. And for example, it can be useful in relation to the fight against exclusionary zoning, identifying patterns and trying to get social mix, etc., etc. This is just a possible use. A second use could be the promotion of citizen participation in urban planning. I remember Professor Nicoletta Rangone's article talking about the use of artificial intelligence in this kind of areas of public consultation. And finally, I have given you the example of Vienna and Madrid, for example, issuing building permits. But we can imagine other uses. But here the question is, obviously artificial intelligence can be a tool of improving administrative behavior, of getting a better administration, good administration, but on the other hand, there are risks. We are going to consider the risks. And let me put the question on the table. Artificial intelligence supporting decisions, total automation, which role for humans? Let's go about that later. Now, let me give you some ideas about the use of artificial intelligence, some examples of the use of artificial intelligence in relation to the right to housing. It's obvious that the use of artificial intelligence can be useful to, for example, identify risks and avoiding bad locations of housing, that it's clear, flood, etc. In relation to the management of the of housing as a service of general interest. As you know, the European Court of Justice has declared housing as a fundamental right, but also we have this perspective of housing as a service of general interest. So in the management of this service, artificial intelligence can be useful, and there are some examples in the field of fighting against homelessness, for example. Another idea is the use of artificial intelligence in relation to automation of homes, domotics, smart house, which can be useful to help all people with that idea of aging in place, or in relation to energy efficiency, for example. There is another use which is increasing. It's the use in relation to the fight against illegal tourist apartments. The terminology can be different in different countries, but Barcelona is probably one good example in that field, using web scraping. There is no artificial intelligence here, as far as I know, but I found this piece of information about Valencia. I don't know about Valencia, but I will be very happy to learn about it. That idea that using digital technologies you can identify, well, it's the relation with the idea of inspections, but not developed by humans, but by technologies. We have a new regulation in Europe now about that, and I don't have time, but this is a promising field in using artificial intelligence. Obviously, there can be a dark side, in the sense that it's not the case, at least in Spain, I don't know in other European countries, but perhaps my colleagues know more than me, but on the other side of the Atlantic, we are receiving news from there about the use of technologies in relation to discrimination in the market. in the US, there is a movement in relation to tenant screening. Landlords and landladies contract companies in order to screen possible tenants. I mean, considering credit history, previous evictions, criminal records, to be, let's say in that way, on the safe side in order to develop the contract. This is more and more frequent, and it has problems because there can be errors, that can be the use of irrelevant data, and it can lead to discrimination. So there are federal guidelines about this topic, and there are case law. I don't have time, but this is the dark side. So my final point in 3 minutes. Again, yes, useful, but full automation, partial automation, what's the role for human beings? I think that we have, very brief, I cannot be precise, but we have to distinguish between different types of artificial intelligence and different types of administrative powers. In my view, it's not the same developing discretionary powers or non-discretionary powers. So it leads to the idea that there are, in my opinion, there are some limits to the use of artificial intelligence, and those limits are legal limits linked to the right and principle of good administration. And those limits depend on the type of artificial intelligence and depend on different perspectives. I don't have enough time, but let me just say that that idea of due diligence or due care, which is linked to the right to good administration, we have thousands decisions from the European Court of Human Rights, in Spain, our Supreme Court, in Italy, even in the Netherlands, for example, in the case Urgenda, there is decisions about due diligence and due care in climate change. This is not the day for climate change, but let me say that this idea is well explained in a recent document issued by the European Union Ombudsman. The European Union Ombudsman addressed to the European Commission, establishing some limits in the use of artificial intelligence based on the idea of the right to good administration. And those limits are based in some considerations. For example, first consideration, the idea that if there is discretion, discretion must be developed. Our colleagues from the common law tradition know very well this limit, and they call it the fettering, the prohibition of fettering. So I think that from the perspective of good administration, we have exactly the same limitation. If there is this discretion, you cannot eliminate the discretion to give the power to the machine. You must exercise discretion. You are obliged, you, human being, you are obliged to decide. Second limit is the lack of empathy and emotions in the case of artificial intelligence. This is a huge area. I cannot enter the area. Just, I will add, sometimes I say to provoke the conversation that machines are psychos, okay? It's just the idea that they don't have emotions, they don't have the capacity of empathy. Even from the technological side, some decades ago, Weizenbaum from the MIT underlined this aspect. And now we have the works of Antonio Damasio from neuroscience and other people, just this point. And my last point is, almost my last point is that artificial intelligence cannot develop abductive reasoning. Okay, I'm on the time right now, I'm finishing. Artificial intelligence cannot develop abductive reasoning. This is a concept developed by a philosopher, Pyrrhus, in the 19th century. Well, the idea is that machines cannot think as we do, and it implies some limits. And the final limit is the idea of the due process, the idea of transparency and the duty to give reasons, and the problem of black boxes. All of them, this is an example of a clear black box cutting medical services without any explanation. It's a real case extracted from Automating Inequality, a book. So that's almost my final slide. Those reasons, this is a controversial topic, in Spain at least, but in my opinion, those reasons explains that the risk of maladministration in using artificial intelligence to take decisions in the field of urban planning and housing is there. This is the idea of a reserve of humanity. Gallone in Italy has used the same terminology, but it doesn't mean that artificial intelligence cannot be used. It can be used as a support in some cases. In some other cases, can take final decision if necessary. But in the case, in my opinion, of non-discretionary powers. So that's all. The European Ombudsman, I'm using the same note, is saying exactly the same and using case law from the European Court of Justice about the delegation of discretionary powers. And there are examples around the world. In Germany, there is a limitation based on this distinction. In Catalonia, we have this distinction. Even the Spanish Charter of Rights. What about the European Union regulation? So it is clear, I'm not going to speak about the protection of data, but it's interesting, Article 22, but just, is the use of artificial intelligence in the field of discretionary powers prohibited by the European regulation? Article 5 says nothing about that. But the regulation establishes a reservation for humans in the case of judges. In the case of judges, yes. What about in the case of public administration? No, it's not clear, okay? So what I'm saying, yes, I'm finishing. What I'm saying, as you see, is quite complicated, but what I'm saying is that one thing is the prohibition of the use of artificial intelligence in some cases. In my case, discretionary powers in the field of urban planning and housing. And another situation is if there is the possibility of using artificial intelligence, then, as Guillermo explained to us, it's the problem, we can say that, of the human in the loop. No? Okay, so the conclusions are clear. One thing is technology, another thing is the rule of law, the rights and the limits. And you know the limits and my explanation, I'm repeating the same, and this is the challenge. I don't know if we will be able of extracting the best from humans and from machines. Thank you, and sorry for a couple of minutes of extra time.
Thank you so much, Juli, for this very suggestive presentation. I really hope we can discuss it later. It's really pity we don't have much time to delve into this issue. The next speaker is Sofia Ranchordas. Is a full professor of administrative law at the Tilburg Law School. She also holds a part-time appointment as a professor of public law, innovation, and sustainability at the Guido Carli in Rome. Sofia is talking us about AI and other technologies of structural exclusion. I'm going to here.
Thank you. Well, thank you very much. It is a pleasure to return to Valencia. I think it's my 4th time in Valencia. I have had the other day I found the first email where Gabriel and Andres invited me to collaborate with Valencia. I think, and I saw it was actually 10 years ago. So it has been a 10-year-long collaboration, so I'm very happy to be here. Thanks for the organization. And I'm very happy that we have already touched upon different fields, because basically I'm also going to mention housing a little bit, because I want to actually bring us a little bit outside of the AI Act bubble, and I'd actually talk about something that is very similar. I want to ask whether basically AI is basically a structure of inequality, or whether it's actually helping us to understand the underlying structure of inequality that we have had for a long time. That is it AI that is actually becoming the reason why people are excluded and discriminated? Or is technology actually bringing so much information together and exposing so much information that we are now seeing that we have had structural inequalities all along? So basically in a new project that I'm developing, I'm basically focused on structures of inequality. AI can be one of them, but also AI can be a way of empowering them, depending on how it's used. So basically, in this new book project, I'm basically trying to show the dichotomy of structures. And by structure, I mean, not only a structure in the sense of a system, a software system, but I actually take structure broadly. So first of all, in my presentation, I'd like to discuss this concept of structure inequality, because this is where it all starts. What is a structural inequality? Because in literature on logarithmic discrimination, we have had so much literature on systemic racism, for example, and how AI exposes systemic racism. But structural inequality is more than systemic racism. It goes beyond just discriminating people on grounds of their race. And basically, why does AI has AI become actually the center of the discussion of systemic risk? Didn't we have it before? And how can AI help us understand the structure of inequality? So basically, I would like to challenge you a little bit to think about these points. So the first point that I would like to bring is, where is this coming from? I did not invent the term structural inequality, and actually the structural inequality idea comes from a broader theoretical framework from political theory on structural injustice, which was originally developed by theorists such as Iris Young. And basically, in this framework, these scholars say that there are inequities that are very entrenched, and they are the result of a complex interplay of historical, political, and socioeconomic conditions. And basically, this interplay is characterized by inequality, dependence, and exploitation. And this results in structural injustice. So in the sense that there are groups of people that have always, or for a long time, been the victims of inequalities and therefore injustice. So think of women for a long time who could not vote, who had, and still have in many countries, a secondary position in society. And this was actually accepted by society and is accepted by society. And also women very often did not claim any other position because they thought it was normal to be like that. And basically, we still have multiple groups in society that actually are subject to these conditions that Iris Young actually defined as being the perfect storm for maintaining structural injustice in society. Namely, the fact that we have a large-scale phenomenon, complex interplay between public and private characters. We had a relational position of dependence. We had harm that was produced to a certain group. But we also had a self-reinforcing structure where basically people could not get out of it. So structural injustice is basically where I'm coming from the idea that there are situations, and there are many situations, in which basically we have structures that are kept in place, and that result ultimately in the discrimination of people, or in the putting at disadvantage of certain groups of people for a very long time. So if you want to actually give some examples to this, it's a study in Italian. I basically analyzed some of these structural inequalities. I focus in Italy, but I will also give some examples from different places. So what are structural inequalities in practice? So think of cancer alleys, the so-called cancer alleys. So what are cancer alleys? Cancer alleys are areas where there is clearly a situation of environmental injustice that is not just created by one company or by one set of circumstances. It is a complex interplay. So for example, in the US, we have the Louisiana's Cancer Valley, where basically due to the lack of regulatory implementation, and also the location of multiple oil companies, the situation is unbearable, and people basically live in areas that are extremely polluted, but also they cannot get out of it because they are too poor to actually move away. They're too dependent on the situation. While there is enough legislation on this, basically it's not enough implemented enough because basically this is a poor area. It's mostly inhabited by African American communities, and basically these communities tend to not have options to move out of it. Another area that is that actually was very much in the spotlight earlier this year in January with the Caravaggio centers of Strasbourg is the so-called Terra dei Fuochi, Land of Fires, which is like an area of 3 million people between Caserta and Naples. I mean, for like the non-Italians, it may be like an unknown case, but basically in this area, like the Camorra Mafia dumped, like for many years, trash, dumped and burned and hid trash that was very toxic. And basically for a long time, due to the lack of of implementation, of enforcement, trash was burned and it actually was contaminating the whole area. But it was so complex to actually address the situation that actually the state failed, as reported by the European Court of Human Rights earlier this year. And the state failed in actually addressing the problem of environmental injustice, allowing the whole area to be extremely contaminated. And basically the result is that people who actually live in this area, they died 10 years before other people in Italy, which is quite concerning, basically. And basically in these areas of environmental injustice, we see this socioeconomic structure of inequalities. They are self-reinforced by the fact people cannot move out of this area. They're dependent on a certain industry, but also government is not really able to move the industry away because basically that area is already contaminated. And this basically creates allows for structures of inequality to develop, which mean that that group of people are actually is already positioned in a very bad position in comparison to other places. Other examples come from housing, social housing mostly. For example, a few years ago we had the Grenfell Tower fire, where basically this social housing tower suddenly disappeared in flames because there have been a lot of problems in the building. But this again was in a case of structural racism, where basically nobody really cared about who was living inside. The municipality actually wanted to build something else in the area. So when actually one apartment caught fire, what happened was that these people that were living in there, they were victims of literally the structure of inequality. The building had a cladding that was highly flammable, which would have never happened in a rich building, basically. And this led to a situation where people actually could not escape. And in social housing, we see very often this, complex, situation where people cannot get out of the structure of inequality because they are too poor to leave. Basically, they're exploited by the situation. The buildings are not well maintained, so they develop health problems. And we see this actually quite often, that this is, basically the structure of inequality is not only it's really literally the architecture of the building, but also the whole policy architecture that is actually characterizing social housing. Another example that I'm not going to delve into, but we see very often is the example of labor exploitation in global value chains, especially in agriculture. Also here we have a perfect storm of public and private intervention, where basically we as consumers want the cheapest vegetables possible, but in order for that to happen, somebody has to be paid very little in the fields. We never think about it, but basically it's a chain of of interdependencies. And even though we probably would never really support modern slavery, we actually contribute to it because there is a very difficult chain to break when it comes to the supply system. And basically labor exploitation, social housing, environmental injustice are just some of the examples where we see these structures of inequality, where basically we have these structural problems that are very difficult to actually address. There are power asymmetries, there are areas of dependency, there is normalization that is done by consumers, but also by the victims of structures of inequality themselves. They just think, well, I don't have a way out, so I'll just contribute to it because this is my only way of surviving. And basically this all happens because we have entrenched socioeconomic structures. So this is why in architecture, we very often talk about how the structure of a building influences well-being of people inside, but basically we can think about that in different contexts. So structural inequalities exist in different ways. And basically when we actually connect this to law, we actually see that they exist, for example, in terms of what the law does to actually address it or not. So in my work, I'm focusing on the fact that sometimes law does not see it or does not want to see it. There is a kind of like legal blindness of inertia, where basically like law allows for problems to be normalized by both the perpetrators and the victims. We also see that law reinforces existing legislation. So in the case of environmental injustice, we have enough laws on environmental law. I mean, if we think of the Urgenda case in the Netherlands, I mean, the law exists. It's just not enough, implemented sometimes. And basically, we see this actually that this has to do with a lack of political will to actually change situations, but also like the fact that we are dependent on how economically certain sectors work. And this is, a big challenge. In terms of the functioning of law, we also know that law works in, to address mostly individual problems, individual failures, siloed approach. So this is private law, this is public law, and we don't have a systemic overview of how things interact. And ultimately, and finally, we also see that the legal system is not always designed to be an enabler of equality. It's actually, it focuses too much on addressing specific things. So in administrative law, we focus a lot on ensuring that the procedure is correct, that the bureaucracy is abided by. And we very often, while focusing on procedure and, on certain elements of, consistency, sometimes we lose sight of the bigger picture. So where does technology come in this situation? So when we have these structural inequalities that are very much underlying, technology can function as a discloser, of course, of these structural inequalities. It can focus as a discloser because basically what we see is that in technology, when we have to code a system, of course we have to insert different variables, historical information, and of course we can choose to actually change the course of things, or we can choose to actually reinforce and embed and exacerbate the situation by basically embedding structural inequalities even more into an AI system. This has been the case of the automation of social welfare. In the automation of social welfare, we actually have seen that technology, on the one hand, has, through scandals, we have seen that technology has exacerbated many structural inequalities, but we actually have become more aware of them. We have become more aware of them because we suddenly realized that actually how the structures were operating, what the problems were. It's still not the ideal case of empowerment, but basically it was a case where we have seen that the systems and the scandals around it have allowed us to think about it. There are cases, though, where we actually have seen a little bit of hope, even though they haven't gone as well as we thought. This was the case of Aadhaar. This was an Indian system where basically what happened was they tried to make sure that people could have access to their social welfare supports through a biometric system. Unfortunately, the biometric system did not actually qualify as well as it should, identification systems of people, but it actually functioned on the grounds of fingerprints, because it tried to actually be aware of the fact that people are not really digitally literate enough to engage with a system, with a computer like we are. And basically, the system tried to actually, include people. It did not include as many people as we wanted because basically it failed to actually disclose the elements of inequality. It failed to actually just basically to show the problems that were embedded into the system. So basically, what AI can actually reproduce or disclose structures of inequalities in different ways. So an AI system can actually reproduce them if it embeds, in the case of social welfare, logics of undeservingness. Some people deserve social welfare, others don't deserve it, so we are going to put in the social welfare system, for example, in a welfare fraud risk assessment, we're going to, introduce certain kinds of risk assessments and scoring that actually, are able to, track some people more than others. The identification process is another way in which basically we can actually reproduce inequalities or basically discriminate against certain groups. So basically also the opacity of systems can contribute to this. How can we actually move ahead and how can we actually ensure that actually AI is not only a structure of inequality, but actually can be a disclosure of inequality? And I'll finish here with this one. So basically what we see is that AI can be a structure of inequality when basically people cannot access their rights, are more often discriminated because AI actually exacerbates inequalities. AI basically makes sure that there is more, like that all the variables that have been used to discriminate against people historically are also present and are exacerbated in the AI system. It's also like a structure of inequality when the identification processes are very much based on what is called data colonialism. And basically when we see that we reproduce inequalities that are historical. This was the case of also of Adahar. Adahar could have been a disclosure of inequality, instead it became an exacerbator of inequality, because it reproduced all the inequalities of caste-based discrimination that already existed. AI is also a structure of inequality if it actually helps us, or if it actually worsens the process of algorithmic discrimination. And lastly, it is also a structure of inequality if it contributes to the lack of critical, ethical, and human oversight, as was discussed by my previous colleagues. If actually the role of the human in assessing the data is not really a critical one, but is basically another element of the structure of inequality. So I'll leave it at that, and I'm happy to answer any questions you may have. Thank you.
Sofia, thank you so much for this presentation about how the AI can be a hint on or running out the exclusion. The next speaker is Dr. Aurelia Colombi Ciacchi. She is a full professor of law and governance at the law faculty at the University of Groningen, and she is the academic director of the Center of Expertise Rethinking Public Interest in Private Relationship, funded by the Dutch government. She is talking about the fundamental rights impact assessment under the AI Act. Thank you.
Thank you very much, Rosa, for this very kind introduction. Thank you so much. Muchísimas gracias to Rosa and Andres for having invited me to this splendid conference. And so my talk will continue the discussion Sofia has started on structural inequalities, and especially concerning, algorithmic discrimination. And on the one side, the discrimination patterns are structural already in society, so that then the disclosure of them, as Sofia has wonderfully explained, AI and technology can help disclosing algorithmic discrimination. And this is also what happened in many cases in practice. On the other hand, however, because of the learning and partly autonomy of the algorithm in the system, they can amplify some discriminatory patterns present in the input, so that the garbage in, garbage out principle works, that some data, for example, nationality or the neighborhood where a certain person is living, are inputted in the system, and then because of the learning capacity of the algorithm themselves, then the discrimination patterns are amplified and live an autonomous life, so to say. And algorithmic discrimination is present both in the public and in the private sector. The report of the European Commission on algorithmic discrimination is already quite old, but gives an overview of the different types of algorithmic discrimination in Europe. And another insightful publication is the chapter by Xenidis, When Computer Says No, and also about algorithmic discrimination in Europe. Well, the country which I'm representing now academically, the Netherlands, is now infamous for especially 3 scandals of algorithmic discrimination in the public sector, which Sofia knows even better than I do. The childcare benefit scandal, the Siri scandal, and the student loans scandal. And well, in the first 2 scandals, there was certainly artificial intelligence in the play. The algorithms were learning learning algorithm. And it was the tax administration, which input some factors like especially nationality of the person applying for public benefits, for child care benefits. And then the system developed some risk scoring, a risk scoring system in order to detect possible fraud. But then this detection of fraud then went completely wrong. Because then the result was a massive discrimination against low-income families with a migration background. And Amnesty International in 2021 depicted the picture in its report, Xenophobic Machines, and the xenophobic machines used by the Dutch public administration, actually. And a very similar pattern, but also more on a even larger scale, because it was a machine learning algorithmic system for a risk indication, so a system risk indication, the series system. It was used. It was introduced by the Dutch government and meant to be used by local authorities all over the country, again to detect fraud in social benefits. And this characteristic of the system was this black box, this intransparent method of collection of data with a vast pool of sensitive personal data collected from a vast range of public bodies, and all then inputted in the system and then creating, again, massive structural discrimination. And here a court in the Netherlands also passed a judgment on this case in 2020. And stated that this system was deployed in problematic neighborhoods and gave rise to discriminatory outcomes and reinforced its existing biases. The fundamental rights applied in this case were the human rights under the European Convention of Human Rights, and especially Article 8. Because of the structure of the Dutch system, where the national constitution cannot be directly applied by judges to test, also to test the legality of legislation. So then the third case about the student loans was also similar. It was about the detection of possible fraud. And again, this personal data, this criteria, including the age, the education level, and the geographical distance of the students from their parents. This pattern, this data were inputted in the system, and the discrimination resulted was not a direct discrimination, because it was not data about nationality or country of origin were in place, but this was an indirect discrimination because data on the geographical location, on the neighborhood, then also constituted a proxy for ethnicity. And in this case, it was the Dutch Data Protection Authority which adjudicated, so to say, in an of course not judicial, non-judicial setting, and the Data Protection Authority concluded that this decision-making, this algorithm decision-making system was discriminatory and unlawful. And again, also here, Amnesty International published a report. So we see this innovation culture in the Netherlands then also leads to problems, but also helps detecting problems, because one might argue then that the structural racism and treating persons with a migration background as potential suspects would be present anyway, and one might argue then that it would be more difficult to detect it without technology. But then, on the other hand, these algorithms then living a life on their own then magnifies the problem. So both aspects highlighted by Sofia are present in these cases. Yes, I'm so sorry. And sorry. So then speaking of fundamental rights, the question is which fundamental rights? Also the Artificial Intelligence Act speaks of fundamental rights generally. And so the question is which fundamental rights? Certainly the European Union fundamental rights, the ones enshrined in the Charter of Fundamental Rights of the European Union, the ones referred to in Article 6 of the Treaty on European Union, including the fundamental rights, including as convention rights in the European Convention of Human Rights. But possibly to a certain extent also the national fundamental rights, at least if they are present in the common constitutional traditions of the member states of the European Union, as referred to by the case law of the Court of Justice of the European Union already since the 70s. And but the fundamental rights on paper are a wonderful thing, but the problem is that in practice, once discrimination has occurred, it's almost impossible to help the victims. Too few cases come before court, and once a case comes before court, it's often too late. Not only because the EU anti-discrimination law is on paper wonderful, well, it's not entirely perfect, but then national courts hardly apply it in many member states. But the Charter of Fundamental Rights is wonderful, but also the potential of the direct application of the Charter of Fundamental Rights have not yet been detected by national judges, despite of seminal judgments like Egenberger, which has made clear, well, the Charter directly applies even in relationship between private parties, where a charter right, where a fundamental right, where a charter provision is sufficiently clear and unconditional. Well, so then prevention instruments become key, and in the Artificial Intelligence Act, then we find some prevention instruments. This risk governance system, a procedural system of protection, ex ante, but the fundamental rights impact assessments are one of the instruments of prevention, of risk assessment. Then fundamental rights impact assessments are required under Article 27 of the AI Act by all deployers of high-risk AI systems, and certainly by all public bodies who deploy high-risk AI systems, and also some categories of private actors. And the procedure is very basic, as described in the AI Act. Previous versions of this article, before the final version which entered into force, previous versions had included also something, also elements of concerning vulnerable groups. But then the final version of Article 27 is much more sketchy and actually watered down. Yes, thank you so much. So it looks like a classic procedural impact assessment scheme, which is likely to become a box-ticking exercise. So fundamental rights already. Well, where do fundamental rights impact assessment come from? Basically from the from the UN model of the human rights impact assessments, which is a voluntary model, it's a soft law. Well, there are now the guiding principles on human rights impact assessments as part of the system of the UN guiding principles on business and human rights, non-binding. So this governance, voluntary governance, self-governance by corporations. the human rights impact assessment and the fundamental rights impact assessment under the AI Act, which are mandatory, are not to be confused with the regulatory impact assessments at the EU level. This is a completely different story. The regulatory impact assessments, it's the European Commission itself, basically, which conducts the impact assessment on the proposed EU action. So basically, the European Commission assesses the potential impact of acts proposed by the European Commission itself. But then the scheme, how an impact assessment looks like, then it's a questionnaire. So then it's an example of questionnaire, and this structure goes through all models of impact assessment until our model under the AI Act. This questionnaire, when it will come out? Next year. So yesterday, the European Commission has announced that in 2026, the European Commission itself will develop guidelines, including the template for a questionnaire developed for impact assessments developed by the AI office. So it will come next year. But already now we know a little bit how this questionnaire will look like. We have some models. The data protection impact assessment is a model which most probably will serve. And then we have also some national models. Also the models developed by the Dutch, by a group of experts. Appointed by the Dutch government. This model is older than the AI Act and is very detailed and very interesting, but there is no time now for this. Let's jump to the conclusion. Every impact assessment is a questionnaire concerning why an algorithm is used and what data and how and which fundamental rights is possible infringed. But then the problem is this self-assessment, so that the organization itself then ticks the boxes and assesses whether the influence will be serious or less serious. The literature, especially Alessandro Mantelero, but also other scholars in the literature have developed critique. And I will not repeat this critique. So there is a lot of work to be done in order to ensure that impact assessments become also a reflexive instrument where, for example, sort of representative of marginalized groups are heard. So there is a lot to do in order to make impact assessments inclusive. Thank you very much for your attention.
Thank you, Aurelia, for adjusting really so very well to the time limit. I'm really sorry we have to make this start fast. The last speaker is Nathan Genicot. He's a postdoctoral researcher at the Perelman Center for Legal Philosophy, Université Lille de Brussels, and an affiliated researcher at the Law, Science, Technology and Society Research Group. He's going to talk about the regulation of AI-based citizen scoring in Europe. Thank you so much.
Thank you. Thank you, Rosa. Thank you very much. And I would like to thank first the organizers of this conference. I'm really happy to be here. And I'll try to be concise because I'm sure you are all looking forward to enjoy the coffee time. So I would like to discuss with you the regulation of AI-based citizen scoring in Europe. And by regulation, I think in particular of the AI Act. So I will stay in the AI Act bubble. And I will discuss in particular of the ban on social scoring, which is one of the prohibited practices in Article 5. As you probably know. But before coming to the AI Act, I wanted to go a bit earlier and talk very briefly about the ethics guidelines, which is a document that has been published in 2019 by the high-level expert group on AI. It's an independent group that published these guidelines, but at the request of the Commission, and it inspired the Commission in its approach to regulate AI. And in this document, they list different use of AI that raise concern for fundamental rights, and one of these use is what they call citizen scoring. And we can read in this text that, I'll try to read, the normative citizen scoring, general assessment of a moral personality or ethical integrity in all aspects and on a large scale by public authorities or private actors, endangers the values of autonomy and of non-discrimination. So they suggest to regulate strictly this kind of normative citizen scoring, if not to ban it purely and simply. In the AI Act, there is no mention in the English version of citizen scoring, but there is a mention of social scoring, as I just said. One really small linguistic remark that I just noticed in the preparation of this presentation is that if you compare the English version with the other version of the text in other languages, we can notice that in the great majority of the EU languages, the translation of social score is really close to the one in English. So, for example, in French, it's notation sociale, or in Dutch, it is sociale score. But there is at least one language, I did not check all the languages, but one language that is of particular interest for many of you, that is slightly different. The translation is slightly different, and I don't know why, but I think it's interesting. So it's in Spanish, since it has been translated as Puntuación Ciudadana. So why did they choose to take Ciudadana instead of Social? I think it would have worked Social in Spanish, right? I don't know, but it says something, and it recalls the ethics guidelines, which were speaking about citizen scoring. So where does this idea of banning social scoring come from? You probably have an answer in mind. It comes from China. Indeed, about 10 years ago, China announced its intention to ban, not to ban, actually, to set up something called a social credit system by which every citizen would be rated according to their behavior. In reality, in China, the reality is a bit more complex and nuanced than what we hear in the media in Europe, but that's another question. Still, it remains that it is because there is something called social credit system in China that the EU decided to ban it in Europe, because in Europe we promote trustworthy and human-centric AI and something that is respectful of fundamental rights, as we all know. And this has been explicitly acknowledged by the former commissioner on internal market, Thierry Breton, which says China uses social scoring to control individuals. Using data captured without the knowledge, citizens are classified, evaluated, and monitored. We are proposing to ban such type of AI in Europe. And what is interesting in this citation is that Thierry Breton says in China, citizens are classified, monitored, and evaluated. No, it's fine. No, I can stay here. They are classified, evaluated, and monitored. But actually, as you know, in Europe, citizens are constantly classified, monitored, and evaluated by AI system or algorithmic devices, right? So what does it mean exactly, and what is the scope of this ban on social scoring? What form of citizens classification would the ban on social scoring, the ban really prohibit? And also, how does this ban on social scoring relate to the high-risk use of the high-risk AI system that are listed in particular in Annex 3? Because when you look at the different sectors that are listed in the Annex 3, in many of them, scoring systems are being used. And we have been mentioning some of them during the previous presentation. So, for example, AI system used to determine access to educational institution, AI system used for recruitment purposes, AI system used for assessing creditworthiness, AI system to detect fraud to social benefits, as we just discussed. All these systems are likely to rely on scoring, so to attribute a risk score to someone, and on the basis of that, to ground a decision. So this means that we have, on the one hand, scoring systems that are made explicitly lawful by the Act since they qualify as high risk, as long as they comply with the requirements of the Act, of course. And on the other hand, we have something called social scoring that is prohibited. And how these two regimes relate to each other. To answer that question, we need to look at the wording of the provision of the Article 5, paragraph 1, point C. I'm not going to read it entirely here, but I'd like to make three remarks. So first, interestingly, the ban covers scores produced and used by public authority and by private actors. And this is interesting because in the proposal that have been made by the European Commission, the ban only, in the initial proposal, it only concerned scores produced by public actors, by public services. And during the negotiation process, this has been modified to extend the scope of the ban to private actors. And I think it's a nice modification that has been done since it's more protective. Second, when we look at the first paragraph of the provision, what does it say? If I sum up, it defines a social score as the evaluation or the classification of natural persons based on their either social behavior or predicted, known, inferred, predicted personal or personality characteristics. And when we look at this definition, what is striking it is that it is extremely broad. If I sum it up a bit roughly, any kind of evaluation made by an AI system of individuals would qualify as a social score under this definition. However, I don't enter into the details, but we can, if you don't agree with me, please tell me. But this doesn't mean that this evaluation would be prohibited. In order for the social score to be banned, it must lead to a detrimental treatment. That's the second part of the provision, which either so the score must lead to a detrimental treatment either in social contexts that are unrelated to the context in which the data was originally generated or collected, or in an unjustified or disproportionate way. So when we read the provision, I think that we can come to the conclusion that the boundary between the high-risk AI scoring system on the one hand and the prohibited social score, the boundary is not sharp, it is not clear-cut. And that's something that I find quite interesting. And I would like to show you that with an example coming from the USA, but we could take examples in Europe as well. So if we think of credit scores, such as the one that we find in the USA, but we could also mention the Schufa in Germany, for example. So in the USA, there is different company. The most famous one is FICO, which produce consumer scores that they sell to banks and other lenders institutions. So these scores, they are supposed to assess the creditworthiness of almost the entire population of India, America. And the banks, they buy these scores before deciding whether or not to grant a credit to someone, right? But what is interesting is that FICO does not only sell these scores to banks, but also to other type of actors, including insurance company, which take into account the scores in their car insurance policies. So they will to assess whether a driver is reliable, they will take into account the credit score of that person. And the same is true in housing. So the landlords, and that was also mentioned earlier, the landlords used to consult the credit score of someone before deciding whether or not to rent the apartment to that person. And also in the field of employment, it's very common for employers to take into account the credit score of someone before recruiting that person. So under the AI Act, I think that taking into account a credit score to decide whether or not to hire someone would qualify as a social score. Why? Because it is the evaluation of someone on the basis of personal characteristics, which leads potentially to detrimental treatments if this person is not hired, and the context in which the decision is made is somewhat unrelated to the context in which the data was generated or collected. Of course, this can be debated, but so what can we conclude from that? And I will end in 1 minute. First, that, as I said, the distinction between a credit score which qualifies as high risk and something called a social score is not clear-cut. We could have a credit score which would become a social score under the Act because of the way it is used. It also means that the qualification of a score as a social score is context-dependent. We need to look at the context, and we do not necessarily need a state building something called a social scoring system at the state level. And that's my last conclusion. This means that I think this provision is interesting in the sense that it is a tool that can be used by citizens to challenge some form of AI-based scoring that could be deployed either by public authorities or by private actors. And in a way, it's a tool that is complementary to some other tools, such as the prohibition of automated decisions under Article 22 of the GDPR. They present different characteristics, but they can be seen as complementary. Okay, so I will end on that note. If you want to read more about this, I have a paper that I'll be happy to share with you. Thank you very much.
Thank you so much, Nathan. You really do it very, very quickly. You have 3 minutes left to talk more about this. Thank you so much for all the speakers. We covered many different issues, and I'm really sure that we have now some minutes to reach the discussion with questions and the insights of the people here. So if is there anyone who would like, yeah, Gabriel.
Yeah. So thank you very much for your wonderful presentations. I have a question for Sofia and Aurelia. Well, I think that the digitalization, the automation of public decisions increases I think this is a disclosure of injustice, of discrimination, because it makes decisions more transparent, more controllable. And, well, in the case of even when AI is involved, and this is good for citizens, of course, but bad for public agents because, I guess public agents don't like to be controlled. The control increases the probability of being held liable, of being punished, and that's not very good for public agents. So this process makes AI less appealing for public agents. And given that, should we tolerate a certain level of discrimination in AI systems in order to prevent public agents from refraining from AI systems? That's my question.
Yeah. So basically, I would actually even extend your question, because I think last time I was in Valencia, we actually discussed the issue of transparency of a very specific algorithm, which was the VOGen, where basically giving transparency to that algorithm would actually even put people's lives in danger. And then it was actually and when you and this is even makes it even bigger, because they basically then you see, well, when you make it transparent, you're shaming like you may shame public authorities, but also like when like giving information can also like be bad when it can actually like be counterproductive if the AI wants to have like a good a good goal, and it's being it can be affected by or undermined by transparency. So I don't think we should. I think I come from administrative law, as as you do, and many of the people here in the room. And I think in administrative law we have a way of balancing the public goals, public principles, and public values. So I don't say necessarily that we should tolerate a certain level of discrimination. I think we should always like balance the goals of public administration. And balancing goals, actually, I think it means that in order to avoid large mass, claims of liability, in order to avoid the goals of using AI or goals of making public administration more efficient, because it is about efficiency, preserving efficiency, right? Not about using AI, but making sure that the public administration can be efficient. In order to preserve efficiency and the good functioning of public administration, consistency, but also without falling into like massive discrimination, I think we have to actually like think of the procedural ways we have to like hit this balance. For example, when it comes to transparency, we have some procedural elements in administrative law. So for example, instead of, we shouldn't aim for full transparency. Full transparency is detrimental to this balance. But what we could think about are the procedural mechanisms according to which you allow like partial transparency, only just enough for the parties to be able to contest decisions. So what we had, for example, like in the recent case of Brad and Dunn Street, which is about like the ability to contest a decision. And I think the ability to contest a decision does not mean that we have to expose fully public administration to liability claims that are massive. I think it means that the parties involved or the judge have to actually have access to the information they need to make sense of the decision, which in administrative law can mean that a lot of things are redacted. So we know that from immigration law when it comes to national security cases. In national security, we have had these very similar cases in which you cannot give too much transparency, but you also want to avoid, want to ensure that there is due process at the same time. And in national security, that we have mechanisms for that, or in complex science cases, we also have mechanisms for that. So what I would say is that instead of tolerating a certain level of discrimination, I think we have to see, I would say perfect equality does not exist, obviously. In order to balance efficiency with fundamental rights and and avoid massive discrimination, we need to think of the procedural mechanisms that can help us to achieve this goal. So I would go for a procedural answer as a professor of administrative law, and I would say that it's not about tolerating, but about finding the mechanisms, the proportional mechanisms of disclosure that can help us achieve an acceptable goal, which may mean that all cases are solved perfectly, but at least that we don't have mass discrimination. So this is how I would see it, but maybe Aurelia coming from the fundamental rights and you law sees it differently.
Thank you so much. I will focus on another aspect of your question, because from your question, I also read, at least between the lines, the possibility that in some countries, other than the Netherlands, because in the Netherlands it's too late. In the Netherlands, the public administration has been using the automatic system for more than 10 years, and even for more than 20 years. Sofia, so and then especially for efficiency reasons, but also because in the Netherlands there is a culture of innovation simply, but especially for efficiency reasons. And these fraud detection scandals, this is simply in order to save money. They have adopted this algorithmic decision making or this algorithmic scoring, risk scoring systems, because it would be too costly to let the to do it with the human resources in the traditional way to discover, to detect fraud. So that's for the Netherlands. So for the Netherlands, it's too late. Other two countries with which I'm familiar are Germany and Italy. Recently, a German colleague told me that in the public administration in Germany, the automation is underdeveloped, heavily underdeveloped, especially because of the federal system. because Germany is a federal state, and especially the public administration is at the state level. So that also the automatic system is also vary from municipality to municipality. It's a huge fragmentation, and many public bodies simply are not yet automated. So that then your question would play, I think, would play a role, because now in some cases, some public bodies in Germany have faced also court cases because of algorithmic discrimination cases, and in Germany it's very easy for a citizen to sue to sue a public body for infringement of fundamental rights. The citizen goes directly to the constitutional court and say, hey, my fundamental rights are infringed by you, public body. So that the public bodies in the course of all this since the 1950s, since the late 1940s of the previous century, the public bodies have adapted to this. Let's caution, let's defend ourselves from possible claims by citizens, and liability claims also, not only fundamental rights-based claims. So that I think you are completely right. I think that the Dutch public bodies now are reluctant to become to enter the digital revolution, the digital age, also because of risk of claims. In Italy, the country where I originally come from, but actually I left Italy 30 years ago, I've heard that also the automation of the public administration is lagging behind. Is lagging behind comparably as in Germany, perhaps for different reasons, and I would suspect that perhaps that this risk or this fear also could help a role. So that I would say your question is completely pertinent. Thank you.
Any other questions? Okay.
Thank you very much for your presentations. I have a question for you. You have said that to any of you, but maybe for Sofia or Guillermo, you have mentioned that AI multiply the inequalities and unfairness because of the historic data. So what is the problem? That all the AI is harnessed with historic data. So what is the solution? Because I don't know if, for example, the AI Act requires good practices, good governance with data. For example, eliminating bias, inequalities, underrepresentation, and so on. But the problem is that the historic data are the historic data. We cannot change them. And even with generative artificial intelligence, general purpose, I think this effect, this structural inequality can be multiplied more and more and more. So what is the solution? I think it's, for example, in the area of healthcare, public hospitals are procuring commercial solutions with the goal to apply these commercial solutions, or even a specific solution to apply on different hospitals. But the hospitals or healthcare centers may have a different socioeconomic circumstances. So this is my highest concern in this. I don't know if I have been clear enough. So thank you very much.
Thank you for your question, Estrella. Just to be brief, for me, of course, there are strategies to mitigate the risks on bias coming from historical bias. And some of them actually are quite accurate, especially the ones that you can apply close to the development area and close to the data that you will actually use in the development that you will make, for example, in a public healthcare system. But I think that historical bias talks more about the limitations of the technology And I think that we should be aware of this. It's just that we have a tool that is limited to some constraints. And one of those is that we build systems based on what we already collected. That might be biased. So I think it's also somehow telling us that the uses that we think for AI are going to be limited, and that we have to play with those rules.
Could I say something with your permission? I think that it's especially relevant in the context of the Spanish Constitution, because we in Spain, we have Article 9.2, which includes a mandate for public powers to remove obstacles to the real equality. So just that point, I mean, beyond the health system or other specific sectors, we have this specific mandate. So we must be aware that artificial intelligence, by default, is a conservative tool. Thank you.
So I'll just delve into the existing, since we also already talked about social welfare. So for example, like in the child care benefit scandal, women were the main victim of the scandal. So like 90% almost. So of course everybody talks on the news about ethnic minorities, but nobody talks about the fact that women were mostly targeted. Why were women targeted by this AI system? Why women? I mean, do women commit more fraud than men? Is it, the thing is, in a project ongoing project, we also look into the history of social welfare. And the welfare system was not designed for women, for single mothers. It was designed for families, for temporary relief of families, when basically the working man would actually have a working accident or would die, and then the family, the widow and the kids would have a support. And this was basically the deserving logics of welfare. Women throughout history, like in the history, there is poverty law. So like when you look at which started in medieval times. For the medieval times, a woman that was by herself, that actually needed help from the state or from others to live, was a woman of poor morality. And basically a woman that did not deserve help, or that actually was seen as a prostitute or something. So it was always seen very badly. And basically, we have actually this historical view, which actually entered into the system. When we designed the social welfare system, we always designed it with this idea of morality. It's for families. When actually we could not no longer discriminate against different groups of people, we had to give it to single mothers as well. But this bias remained in the system. It remained embedded into the system. So basically, I think what we have to distinguish is between the tech issue of training data with training the system with historical data, which, as Guillermo said, we can correct it. We have technicalities that we can actually correct, interpret biases, and remove bad data. We can do that. But what is difficult is what people think, our mentalities, seeing a single mother as something bad. And this is basically what AI systems have been doing. They actually just are reproducing what we have always thought throughout centuries. And they just put it on our face, and then it becomes uncomfortable because then it's like thousands of people being affected. But historically, these people were always discriminated against. And what I think, what I'm thinking about also in my project on structural inequalities is that we have to actually make people aware of these historical biases, of our mentalities. And we also have to, by making people aware of these structures of inequality, which can be morality, actually, we actually can then build AI systems that are a little bit more critical. But the technology is there. Technology exists. Technology we can make technology be very nice to us if we want, but we have to want it. We have to have the political will and the social will to actually want this. And then we have to infuse the system, of course, with, of course, machine learning can also do things by themselves. But I think we have to code it, because the thing is, with the social welfare fraud scandal in the Netherlands, technology worked to discriminate against the people that the Dutch government wanted to discriminate against. It functioned very well. But and this is the issue. We have an inequality that was just reproduced, and I think we have to talk about not only technology, but about also policy making. And only if we change policy making and if we exactly know what we want to achieve with a certain policy, then we can actually correct the historical data, reinterpret it, make people more aware of like their critical role in interpreting the data, but we have to change mentalities. And this is the reason why I think it's important to talk about the, structural equalities in tech, but also beyond tech.
Muchas gracias a todos. Thank you so much. Soy consciente de que hay más preguntas sobre la mesa, pero si os parece bien, vamos a trasladar estas preguntas a la pausa café. Os ruego rapidez porque vamos muy justitos de tiempo en la Facultad de Economía y seguimos discutiendo. Thank you so much for everyone.